Item 31. Principal makes oath that on or about the 25th of February 2010, I received in the mail to my client in Germany a court order that was signed by David Dunkley. This court order is provided as an attachment in the file as follows: 07 David Dunkley Court Order 2010-02-19 PDF. This entire court order will now be read into evidence as part of this affidavit. Okay, you're now going to have read into the record for this case the court order of the 10th of the 2nd 19 for the Federal Magistrates Court of Australia, issued by David Dunkley. Okay, it was sent to care of me via a customer. Dear Sir, Madam, Nolan, I refer to the above enclosed judgment and orders delivered by Federal Magistrate Dunkley on 19th of February 2009. It was actually 19th of February 2010, so Teresa Owen can't tell the right year. This is how incompetent these people are. They can't even get the years right on their letters. So, it comes down to here: Peter Nolan, care of a client in Germany, and the Federal Magistrates Court, etc., etc. Sarah Bevan Family Lawyers, order dated 1902-2010. Now remember, you have now seen the video of the court meeting, and so you can see quite clearly in the court meeting that David Dunkley is being a criminal and impersonating a magistrate, right? And you can see him refuse time and time again to agree that I can enter the court with my inalienable rights intact, meaning his condition for entering his court is that you waive all your rights so that he owns all the property so that he can adjudicate on it. That's how that works, okay? They claim they own the property so they can adjudicate on it. I had claimed my property back and owned it, and he was claiming if I boarded his pirate ship, which is what the little balustrade is meant to signify, stepping onto a ship, which is where you get put in the dock when you go to a court and you're being charged, you get put into a dock because you're on a ship, right? So the ship analogy, the ship language and analogy is there, and that's what they mean. It's a pantomime around a ship. So when you go into a court, one of these courts, they are saying by walking into the court, you are waiving all your property rights, so that gives them the right to tell you what you can have back out of what you thought was your property, okay? So it has a file number between Peter Andrew Nolan, Jennifer Marguerite Nolan, Federal Magistrate David Dunkley. That's a lie because he was not acting as a magistrate. He's acting as a magistrate of a Mickey Mouse McDonald's court. 19th of February 2010, Parramatta. Upon application made to the courts by applicant in person and Mrs. Bevan for the respondent, the court orders that the parties shall direct Watts McRae solicitors within 30 days to the date hereof to disperse the sales proceeds held on behalf of the parties in Watts McRae Trust account in the following priority. And this is the lie. This very first piece is the lie, and I will deal with that in a later section in my affidavit. You can see it says, in payment to the wife the sum of $12,931, whatever this means. In payment to the husband the sum of $20,767 for whatever reason. In payment to the wife of the balance. Okay. Now point 2 says, the parties shall direct the real estate agent who acted on the sale of 8 Schofield Parade, Pennant Hills, to disperse any monies held by that agent on behalf of the parties as 70% thereof to Mrs. Nolan and 30% thereof to Mr. Nolan, right? However, all monies from the sale of 8 Schofield Parade were already at Watts McRae, okay? So this 70-30 is put here deliberately with malice of forethought and misleading to mislead anybody reading this to think, oh, the proceeds of the sale of the house are 70-30. Okay? No. There was nearly $300,000 in the proceeds from the sale of the house, $12,900 to go to the wife, $21,000 to go to me, and the balance to go to the wife, meaning the other $270,000 or $260,000 in payment to the wife of the balance means $260,000 to the wife. And nothing is over here. 70% and 30% of nothing, because disperse any monies held by that agent. There were no monies held by that agent. All the money was up here at Watts McRae. So that means David Dunkley, Justin Dowd and Sarah Bevan colluded and cooperated to put this statement together. Okay, that's what they did. Now, and I deal with that in more detail, but that's what you want to read from the court orders. Now 3, Mrs. Nolan shall be solely responsible for the payment of the loan, formerly the overdraft, now in her name, and that was an overdraft with Irish Bank. Mrs. Nolan shall be entitled to the balance of the monies in the joint names of the royal parties in the Royal Bank of Canada. Well, that was €1,000, so who cares? That the husband and wife do all acts and things and give all consents and execute all documents and writing necessary to give effect to orders made herein. Okay, and of course I wasn't going to do that because the orders were rubbish. In that in the event either party refuses or neglects to execute any deed or instrument by any date provided herein, or within 14 days of being requested to do so, then the registrar of the court be appointed pursuant to section 106A to execute such deed or instrument in the name of the party and to do all acts and things necessary to give validity to the operation of the deed or instrument. Yeah, well, they had no jurisdiction. It is ordered that subject to the proceeding, the husband and wife are to have the sole right, title and interest in any chattel, goods, furniture and other property not previously dealt with as part of these orders, which are at the date hereof in their possession respectively. Any money, shares, debentures and superannuation entitlements not previously dealt with as part of these orders, which stand in their sole name irrespective of the date hereof. Okay? Stamped by order of the court, signed by David Dunkley, pretending to be a federal magistrate Dunkley. Okay, so here is the so-called reasoning, which is just more rubbish. You know, they refer to somebody's previous case and then use a previous case to justify the rubbish they're doing in this case, which is just another criminal magistrate making up rubbish as he goes along, and then they use the same rubbish as input for their later rubbish. That's what's going on. Okay. So hearing date 26th of November 2009, delivered on 19th of February 2010. Applicant appearing in person, solicitors for respondent Sarah Bevan Family Lawyers. Orders. So this is repeated, the orders. And then it has reasons for judgment. And this is really interesting to say that there are reasons for this judgment, given the fact that he had no jurisdiction to make this judgment. Mr. and Mrs. Nolan have been engaged in litigation in one form or another before the Family Court of Australia and now the Federal Magistrates Court since December 2007 relating to issue of property settlement. Neither party has lived in Australia for any length of time recently. Mr. Nolan currently seems to reside in Germany. Mrs. Nolan resides in Ireland. Both are Australian citizens. Background: Mrs. Nolan was born on 9th of October 1962. It's true. Mr. Nolan was born on 11th of January 1964. They began living together in January 1987. True. They were married in Wagga Wagga, New South Wales on October 7th, 1989. True. They separated on November 12th, 2007. Well, you can argue whether it was November or August. Doesn't matter. I did not sleep in the house after August 2007. They have two children, Josephine, who was born on 24th of May 1991, and Joshua, born on 20th of May 1993. Contender, no evidence of that has ever been presented because no paternity test was ever taken. On 1 July 2008, proceedings for property settlement were transferred from the Family Court at Parramatta to the Federal Magistrates Court at Parramatta. The parties were divorced by order of Registrar Campton, sitting on the Federal Magistrates Court, Parramatta, 8th of December 2008. There were a number of procedural hearings in the Federal Magistrates Court in which both Mr. and Mrs. Nolan were legally represented. Mr. Nolan's solicitors filed a notice of ceasing to act on the 3rd of August 2009. Mr. Nolan thereafter became a self-represented litigant. Parties have at some stage sought orders from the Circuit Family Court in Dublin. principal asset of the property dispute is the proceeds of sale of 8 Schofield Parade, Pennant Hills, and you see it says which is held in the trust account of Watts McRae's lawyers. Watts McRae were formerly Mr. Nolan's solicitors. Principal asset of the property dispute is the proceeds of the sale of 8 Schofield Parade, which is held in the trust account of Watts McRae solicitors. So there is the proof that David Dunkley knew exactly what he was doing on the order, claiming the 70-30 was a split from the proceeds held with the real estate agent. He knew that the entire amount was with Watts McRae, and he's written it in the court order. So you, sir, sitting on the jury, this is the irrefutable, absolute proof that David Dunkley knew for sure and for certain that the proceeds of the sale of 8 Schofield Parade, which is held in the trust account of Watts McRae lawyers. Okay? He knew that's where the money was. So he knew when he wrote and the remainder to be dispersed to the wife, he knew he was sending $260,000 to the wife in that statement. Okay? And you, Mr. Gentleman, sitting on the jury, you want to determine whether that is a crime or not. Okay? Is it a crime to deceitfully send $260,000 to a female? Okay? And the obvious answer is, of course it is a crime, right? But you can make up your own mind about that. Now, Mr. Nolan commenced proceedings by filing an application for final orders in the Family Court in Australia at Parramatta on 3 December 2007. In support of that application, he filed an affidavit which he swore 13th of June 2008 and a financial statement which he swore 28th of November 2007. Apart from these documents, he had filed no other relevant material. Okay? Filed relevant material. But David Dunkley was given a relevant material. He has, however, kept up a barrage. So when is email equated to cannon fire? Because barrage is cannon fire. You have a barrage of cannon fire. But emails? Since when is email like cannon fire? Why the emotive word barrage? Okay? Kept up a barrage of email communication with the court and with Mrs. Nolan and her solicitors. Would this be because all these people refused to respond to politely framed communication? Is that why I had to send me emails repeatedly? There was tendered on Mrs. Nolan's behalf a ring-back folder of many, many emails. Yeah, so there were some emails. Is there any crime in sending somebody emails, right? Especially when the person receiving the emails refuses to reply. They became Exhibit A. Some of the emails dealt with the property issues in dispute. It is thereby clear Mr. Nolan could have prepared and filed documents further supporting his case had he so chosen. Well, the fact is that Mr. Nolan did prepare documents and have them presented under common law jurisdiction to David Dunkley, further supporting his case, and I did choose that. Okay? So David Dunkley did have those documents. Mrs. Nolan relies on an amended file response 18th November 2009, her affidavit sworn 10th November 2009, her financial statement sworn 20 November 2009. Judicial Registrar Johnson made orders on 16th June 2008 relating to the sale of the property at 89, it's 8 Schofield Parade, Pennant Hills, and the disbursement of the sale proceeds pending further hearing. So here he is admitting that Registrar Johnson made those orders, right? 18. Neither party asserted that this court lacked jurisdiction to hear the case. Let me repeat that. Neither party asserted that this court lacked the jurisdiction to hear the case. Each submitted to the jurisdiction to the court. It is clear that the court has jurisdiction to hear this case. Okay, let me repeat this one more time for you in the jury and you in the public. David Dunkley says on his order, neither party asserted that this court lacked jurisdiction to hear the case. Each submitted to the jurisdiction to the court. It is clear that the court has jurisdiction to hear this case. You just saw me on video many times over say, I do not consent to your unwanted adjudication services, David, and if you force me to, if you attempt to force these adjudication services on me, I will charge you 1 million ounces of gold. You saw that on the video, right? This is how big a bunch of liars the legal fraternity are in Australia. It's right there in front of you in black and white, and you cannot deny it. So 19. After Mr. Nolan's solicitors ceased to act for him, he has done nothing to further prepare his case. That is a lie. David Dunkley was presented with compelling and lawful documents showing that I owned all the property. Okay? I owned all the proceeds. Okay? And he is claiming that I had done nothing. Wrong. You saw me present to Louise Henderson on the 24th of, I got the default judgment. That default judgment was handed to Jennifer and Sarah Bevan before entering the court. So before entering the court, Jennifer and Sarah Bevan had a document proving that I owned all the property. Okay? So the statement, after Mr. Nolan's solicitors ceased to act for him, he has done nothing to further prepare his case, is just a bigger lie as what was said right above it. Now on 25th of March 2009, the case was listed for final hearing on 26 and 27 November 2009 as a priority hearing as the parties were travelling from overseas. Okay. 20. Some more lies. Mr. Nolan has been obstructionist of the proceedings being heard. Rubbish. You saw me politely stand there in the court and ask many times over, may I enter the court with my inalienable rights intact? And David Dunkley actually on one occasion said no. Now he turns around and lies and accuses me of being obstructionist of the proceedings being heard. He had no jurisdiction to hear those proceedings. On the appointed hearing date of 26 November, he was present at the court and initially refused to enter the courtroom. No, that's a lie. I didn't refuse to enter the courtroom. He then entered the courtroom and remained standing for the duration of the hearing at the back of the court. No, at the back of the courtroom. He refused to identify the documents that he had relied on. No, David had a copy of those documents, and you saw me say in video many times that I'd be quite happy to produce those documents as long as I could enter the court with all my inalienable rights intact. So then he claims he did not answer a notice to produce. False. Okay, I was quite happy to produce as long as I preserved my inalienable rights. Then listen to this. From David Dunkley, a supposed federal magistrate, he mouthed inanities about, quote, preservation of his inalienable rights, end quote. Okay, US Constitution. All men are born equal and with certain inalienable rights. Okay, those including the right to life, liberty, and the pursuit of happiness. We are endowed by our Creator with certain inalienable rights written on the US Constitution. So what is written on the US Constitution, according to David Dunkley, is inanities. Now, listening to this video, you want to understand that an Australian federal magistrate calls what's written on the US Constitution, widely regarded to be a very well written constitution, even if it is a fraud, is inanities. Okay? You want to understand that. And you want to understand that David Dunkley, while committing the crime of impersonating a public officer, meaning a magistrate, claims that your inalienable rights and preserving your inalienable rights are inanities. You want to understand that is how criminal this man is. Next, his behaviour and demeanour, it appeared, was intended to be provocative of both the mother's legal representative and of the court itself. No. Did you see me be provocative? Okay. I think you saw David Dunkley be provocative. I think you saw David Dunkley refuse to answer questions. Okay. But you didn't see me refuse to answer questions, and you didn't see me being provocative. And it's on the video. When that did not succeed in gaining the attention he seemed to desire, he began to be personally disrespectful and provocative of the court, engaging in such actions as referring to me by my first name and seeming to photograph and record the proceedings using his mobile phone. Okay, so David Dunkley is claiming that I can be provocative of the court. Well, the court is an inanimate object. It's a proper noun. It's describing a collection of things that are inanimate, okay? And claiming that I could be provocative of that and disrespectful of that. Well, how can I possibly be provocative of a court or disrespectful of a court? And he's claiming that such actions as referring to him by his first name is disrespectful. Really? Calling somebody by their first name is disrespectful? Gee, I've been disrespectful to a lot of people in my time then. By contrast, I asked David Dunkley many times over to call me Peter and to stop calling me Mr. Nolan, because Mr. Nolan is a legal entity and it's not me. Who was being disrespectful? David Dunkley was being disrespectful. That's who was being disrespectful. Okay? Now it says, seemingly recording the proceedings using his mobile phone. So David Dunkley has written in this order that he was absolutely clear that I seemed to be recording the proceedings. Therefore, he agreed and consented to the recording of the proceedings. Now he says 21. Mr. Nolan would not submit to cross-examination. No, again, false. That's a lie. I would be perfectly happy to sit down and have a conversation with David Dunkley. You saw me offer to do so about half a dozen times. Okay? I asked David whether I could enter the court with all my inalienable rights intact, namely my property rights, and he said no. It's in the transcript, it's on the video. When I asked that question, he said no. He meant, I want you to waive all your rights and come in here and give me all your property, then come in here and I'll tell you how I'm going to divide it up. Well, why would I do that, given that I owned all the property at the time? Okay? So he's trying to disparage me. He's trying to say that I was being disrespectful, provocative, and would not submit. Why should I submit? I was a sovereign in the room. I was the master. He was the servant. Why would the master submit to the servant? Okay, so little if no weight would therefore be normally attached to his financial statement and affidavit, except that by her affidavit sworn by 10th of November 2009, Mrs. Nolan accepted many of the assertions contained in Mr. Nolan's affidavit. Exhibit A also contains some emails from Mr. Nolan that assist, for example, with identification of matrimonial assets. Okay, evidence of Mr. Nolan. Mr. Nolan concedes that both parties' children continue to reside in Ireland with Mrs. Nolan after separation. No, I don't concede that. I don't concede that they are my children because there's no paternity test. I concede that Mrs. Nolan's children continue to reside with them after separation, but not my children. I don't know that they're my children, and no evidence has been presented to that effect. 23. He states that in 2005 a company, Business Intelligence Limited, was incorporated in Ireland. He and Mrs. Nolan were the only directors and shareholders. As a consequence of proceedings in the Family Circuit Court in Dublin, Ireland, a number of restraining orders were made affecting the company and the parties' dealings with the company. Mr. Nolan asserts that he has not worked since 2007, although his financial statement sworn 28 November 2007 stated he then had a gross income of $2,500 working as a consultant for the company. Now it's $250,000. Okay, so they got that wrong. $250,000. Mr. Nolan, current emails indicate he remains a company consultant. He asserts that since the commencement of proceedings in Ireland, he has incurred debts totaling $275,000, which is true. Okay. Mr. Nolan provided no documentary evidence in support of alleged debts. Why should I have to? His financial statement disclosed the following property: half interest in 8 Schofield Parade, Pennant Hills, estimated value $375,000. Bank account in Canada, a Volvo, the car, the contents, superannuation assets, and apart from liabilities referred to, his financial statement disclosing their mortgage with a payout figure of approximately $225,000. He asserts money were loaned to the parties by his brother, that this money has not been repaid. Mrs. Nolan, in Mrs. Nolan's affidavit, she confirms the history previously referred to herein. She says that she was employed full-time until just prior to the birth of Josephine. After the birth, she returned to work full-time until Joshua was born. She now works as an office administrator. Prior to the parties' relationship commencing, neither had any assets of significant value other than a few $1,000s in savings. In either 1987 or 1988, the husband's brother is said to have given the parties $15,000, which was used to discharge a mortgage over their matrimonial home. She says that the husband's brother has forgiven the debt and does not want repayment. False. The amount was $25,000, and she was browbeating Christopher into trying to say he doesn't want to be repaid, but the agreement was not between her and Christopher. The agreement was between me and Christopher, and she has nothing to do with that agreement. And so what she says about what Christopher says is not relevant. Okay. 35. In 1992, Mr. and Mrs. Nolan purchased a property at 8 Schofield Parade, Pennant Hills, as joint tenants. Thereafter, she was principally homemaker and parent, and Mr. Nolan focused his energies in income earning. She says that in the late 1990s, Mr. Nolan received a redundancy payment of about $50,000, which was applied to the parties' debts. False, that isn't a lie. The amount was $30,000. Okay. She says that since separation, she has received only minimal financial assistance from the husband, consisting of 3 payments totaling €1,300. She says that on 9 October 2007, the husband withdrew €10,000 from a joint account in Jersey and used those monies on his own personal account. That is a lie, which I have denied, and there is no evidence that that happened. The money was transferred by accident, and that I have in a letter from the bank, and I have the email trail from Jennifer to the bank demonstrating that the bank had told her that the transfer had occurred by accident. So Jennifer is lying. She says the last knowledge she had of the company's earnings in 06-07 financial year, the company earned approximately €250,000 in consulting fees and software sales. False, it was $225,000. She claims to know what was happening in the company, but she can't read the bank statement. She says that during the period 05-07, the company paid a salary to Mr. Nolan of between €6,000 and €8,000 a month. She says that's after tax, €6,000 to €8,000 a month after tax. She says that since 2007, although she has remained a director of the company, as a result of orders obtained in Ireland, she has no knowledge of the company's financial affairs or otherwise. She discloses a company tax debt of $222,885. It's not a tax debt, that's a debt to Philip Lee Solicitors. She says that in early 2009 she became aware the company may have been dissolved through the company registration office in Ireland and believes no action is being taken to recover the company tax debt. The former matrimonial home at Pennant Hills has been sold on 11th May 2009. The net proceeds of sale, approximately $251,200, were deposited into the trust account of the husband's then solicitors, Watts McRae, where those monies remain to date. There is no interest being earned on these monies. Now, I think it was closer to $290,000. Okay? And I would have to go back across that. But here again, I want to make it clear to the jury and to any member of the public who is reviewing this case. David Dunkley says on his court order, the former matrimonial home has been sold on 11 May 2009. The net proceeds of sale, approximately $251,000, were deposited into the trust account of husband's then solicitors, Watts McRae, where those monies remain to date. There is no interest being earned on these monies. That's what that says. Now let's just go back up to the order. The parties shall direct Watts McRae solicitors within 30 days of the date hereof to disburse the sale proceeds held on behalf of the parties in Watts McRae Trust account in the following priority. In payment to the wife, the sum of $12,931. In payment to the husband, the sum of $20,767. In payment to the wife of the balance, $200,000. Now I think that balance was $260,000. Okay? So in payment of the wife to the balance, and then this clause thrown in to mislead people to thinking it was 70-30. That's what's in the court order. There's the stamp. Okay? So, that's this point. 41. A further small undisclosed sum remains with the trust account of the selling agent. Okay, so a further small undisclosed sum remains with the trust account of the selling agent. Actually, I don't believe there was anything left. And that's what the 70-30 is applied to, if there was anything there, right? And I think there was nothing there. This is how criminal they are. This is how deceitful they are. Mrs. Nolan says that she has accepted responsibility for a joint overdraft of the parties' account, which has a balance owing of approximately €8,000. This is why the direct debits were stopped. This is why the direct debits were stopped. The overdraft on our Irish joint account was about, I thought, €7,000, but here's the claim, €8,000. It was in that region, €7,000 or €8,000. The bank could not see themselves being paid back anytime soon, and they froze the bank account. She says that all proceedings in Ireland were dismissed as a result of parties being divorced in Australia. This dismissal was a result of what she described as jurisdictional issues. She says that she continued to support both her children, even though Josephine is over the age of 18 and Joshua continues with the high school. Well, they're her children. Of course she should support them. She said they were her children. She should support them. Her financial statement discloses a before-tax income of $1,212 per week. She asserts her personal expenditure is $8,856 per week. She has a superannuation investment in an approved deposit fund of $14,000. She says she has a debt to family and friends of approximately €5,000 arising from post-separation expenditure. Okay. Mr. Nolan did not cross-examine her, and her evidence is therefore accepted uncontroverted. Okay. Mr. Nolan did not make himself available for cross-examination, therefore little weight is attached to his affidavit evidence or the evidence of his financial statement where it is contradicted by Mrs. Nolan's evidence. Well, that's because the demand was that I waive all my property rights to be cross-examined. Okay. So this is a bit of rubbish of case law. Okay. Now, they claim $251,000 on deposit. I think it was more than that. Okay. Husband's household contents, added monies deducted from Jersey account by husband. Okay. This is false. This €10,000 was not stolen. Monies transferred by husband to the Instant Business Intelligence bank account. Yeah, I took that. That's fine. The overdraft, the wife's superannuation, the husband's superannuation, the non-superannuation assets, the superannuation assets. Okay. The husband, through his conduct, has engaged in willful non-disclosure. False. David Dunkley had copies of my affidavits and had copies of all the documentation he needed. In his affidavit, he says he has not worked since 2007, yet he filed at the same time a financial statement indicating an income of $2,500. No, I didn't do that. I filed a financial statement in 2007 saying I earned €225,000, right? Since that time, he has managed to remain living overseas, returning from time to time in Australia. He would not answer a notice to produce. He would not be subject to cross-examination. Therefore, on the balance of probabilities, he has more income and assets than he has disclosed. The quantum of that income and the value of that assets are unknown. Okay? So, I was under no obligation to disclose anything to these people. I was not under any obligation to be cross-examined because I already owned all the property through a properly executed claim of right. Okay? 55. It is more probable than not that he continues to work as an IT consultant, earning considerable income. So, it's possible, it's probable. So what? You need some proof to do anything. So 56. No findings can be made for the asserted debts claimed by the husband. He provides no documentation related to the debts. He would not be cross-examined. Why should I be? Why should I be cross-examined at all? Remember, on November the 24th, default judgment to Louise Henderson. I owned the house. I owned the proceeds. 24th of November. My claim of right was also not challenged. I owned the proceeds. The gift from husband's brother of $15,000 in 1987-1988 is a contribution referable to the husband. Apart from this, until the date of the hearings, the parties' contributions have been equal. The parties' contributions have been equal is a complete joke and a lie. Firstly, it was $25,000 and it was in 1989. The parties' contributions were equal is a complete lie. Mrs. Nolan, having made her contribution as a homemaker and parent and through her income earning, well, she quit work in 1993. Okay, and didn't work for 16 years of an 18-year marriage, but apparently that's through her income earning. Mr. Nolan having made his contribution principally through his income earning and his assistance. Oh, my assistance as a parent. She's the parent and I'm only assisting as a parent. Thank you very much for the insult. As a consequence, the husband has made a 52% contribution to the acquisition of the party's assets and Mrs. Nolan a 48% contribution. Really, he can tell this. A woman refuses to work, refuses to be a good mother, refuses to do anything useful, and that's 48%, and you men on the jury want to think about what that says. 58. Mrs. Nolan has the care and control of one child under the age of 18. She's receiving no regular child support for that child. She's receiving no regular child support because no paternity test was made and she denied the paternity test, so she waived any right to claim child support. Okay. Given the husband's non-disclosure on the balance of probabilities, Mrs. Nolan's income earning capacity as an office administrator is significantly less than Mr. Nolan's income earning capacity as an IT specialist. So what? Mrs. Nolan was the one who decided that she didn't want to go to work anymore. By the way, Mrs. Nolan's brother has been slandering Mr. Nolan for more on 2 years, and Mrs. Nolan has also ensured that Mr. Nolan does not have a work permit in Europe. Therefore, Mr. Nolan's income earning capacity has been severely damaged due to the action of Mrs. Nolan, which is a crime. Okay? 60. There is no evidence that either party has any issue as to health, apart from the fact that I testified that I was suicidal. Okay. 61. There is no evidence that either party has repartnered. 62. Each of the parties has modest superannuation. Modest, call it non-existent. Having regard to paragraphs, etc., and non-cautious approach as set out in the decision for where and where for the non-disclosure made by Mr. Nolan, a 22% adjustment is made in favour of the wife for factors set out in 7S75. So here is David Dunkley saying, well, based on information I'm pulling out of my arse, I'm going to make a 22% adjustment. Okay? You men on the jury want to read this. Having regard to paragraphs 58 and 62 above, i.e. David Dunkley is saying, I have no evidence in front of me, so I'm going to make up information and pull it out of my arse. I'm going to make a 22% adjustment in favour of the wife. Okay? That's what he's saying. 64. The results in an overall property settlement of 70% for the wife and 30% to the husband. Okay? Now, that's what he's saying, 70-30. But remember, he has deceptively given 95% of the property to the wife, including all the household furniture and everything else like that, right? You need to remember all that went to the wife as well. Okay? So this is part of the lie, and Jennifer is an accomplice to this lie, and she's the beneficiary of this crime. 65. An order will be made for the repayment of the overdraft for which the wife has assumed responsibility. It is clearly a liability for the parties being incurred prior to their separation. It relates to their marriage and was used for family expenses. As a consequence, the wife will receive 70% of the net superannuation and non-superannuation assets, $328,000, after an amount equal to the overdraft is first deducted, which equates to $220,000. Okay? So he's saying that Mrs. Nolan will get $220,808. Okay? Mrs. Nolan will retain her superannuation investment, her car, the existing bank accounts. She will therefore receive $217,000 from the sale of proceeds in the Watts-McRae Trust account. So bullet 67 on an order written by David Dunkley. Mrs. Nolan will retain her superannuation investments, her car, the existing bank accounts and her furniture. She will therefore receive $217,505 from the sale proceeds of the Watts-McRae Trust account. She will retain responsibility for the loan she has borrowed from friends, that is, a post-separation borrowing. 69. As a consequence of the above, the husband will receive 30% of $328,371, which equates to $98,511. Okay. Mr. Nolan will retain the benefit of his superannuation investment. He has already received the added back funds he will receive from Watts-McRae account, the sum of $20,767. So it says, he has already received the added back funds. Really? I've received the added back funds? Would anybody like to prove that? He will receive from Watts McRae Trust account $20,767. What added back funds? The small amount that remains in the trust account of the real estate agent will be divided as 70% to the wife and 30% to the husband. Okay. Having regard to the above, no further adjustment is warranted with respect to justice and equity. So, what they're saying is justice and equity is based on no proof at all. I'm going to pull numbers out of my ass. I'm going to give 70-30 to the wife. However, I'm also going to say that the husband, even at 30%, is going to get $98,000, but these mysterious added back funds, which I don't have, okay, I only get $20,767, which begs the question, where did the other $78,000 go? So first of all, where's the other missing $78,000? Okay, where did that go? Presumably to Jennifer. Second of all, the 70-30 split is a complete lie and is not based on anything. It's based on David Dunkley making stuff up. That's what it's based on. David Dunkley making stuff up. Now further, David Dunkley made stuff up to try and justify this court order. However, he at no time had any jurisdiction over this property. And you, Mr. Jury Member, can ask Jennifer for where is the documentation showing that David Dunkley had jurisdiction to take this money and give it to you. And if you, Jennifer, cannot show documentation where David Dunkley had jurisdiction to give you this money, you are guilty of the crime of theft because you received stolen property. Okay, that's how that works. So this ends the reading of the David Dunkley Court Order of 2010-02-19.